All right, great. Thank you very much. Half a day, everyone. Thank you for being here. The Committee on Culture and Justice is now called to order. It's Thursday, September 28, and the time is 5:33 p.m. Notices for this public hearing were disseminated via email to all senators and all main media broadcasting outlets on September 20, 2017, and again on September 26, 2017. The notice was also published in the Guam Daily Post on September 21 and in the Pacific Daily News on September 23, 2017. We have two agenda items today, Bill number 175, introduced by myself, and Bill number 177, introduced by myself. We'll read the titles later. I would like to thank Senator Regine Bisco-Lee for being here this evening, and thank all of you. The two bills that we're discussing today are both regarding family violence. We know nationally and in Guam, this continues to be a serious issue for our community. Based on statistics from the National Coalition Against Domestic Violence, 1 in 3 women and 1 in 4 men have been physically abused by an intimate partner. On a typical day, domestic violence hotlines nationwide receive approximately 20,800 calls. And in Guam, according to the Judiciary's 2016 annual report, over the last 3 years, family violence has consistently been the top offense charged of all their cases annually. In 2016, there were 494 cases involving family violence charges, and 128 of them were felony offense. Both of the bills that will be discussed tonight were introduced in an effort to protect victims and witnesses of family violence. We'll start with Bill number 175. It is an act to ensure that Guam's family violence laws are enforceable and that family violence cases are successfully prosecuted by amending Section 30.10 of Title IX Guam Code Annotated. The intent of the bill is to clarify the existing definition of family violence following the Supreme Court of Guam reversal earlier this month of a family violence conviction due to the 9 GCA Section 30.10A2 being unconstitutionally vague. The Supreme Court of Guam in People v. Shimizu, 2017 Guam 11, determined that the language in the statute defining family violence as including, quote, placing a family or household member in fear of bodily injury, unquote, did not provide fair notice to ordinary citizens as to what conduct it prohibits, and it did not establish minimal guidelines to govern law enforcement. So the goal is to amend this act to ensure that the statute provides fair notice as to what conduct it prohibits and to ensure that it establishes required guidelines for law enforcement. We will now accept testimony on Bill 175. I'm sorry, let me just read the part of the bill where we include the definition. So in place of the language that the Supreme Court found too vague, this bill proposes to add this language. It proposes to add subsection 2, but under subsection A. So subsection A says family violence means the occurrence of one or more of the following acts. And the one we're adding is communicating to a family or household member a threat to commit or to cause to be committed bodily injury or a crime of violence dangerous to human life against the person to whom the communication is made or another, and the natural and probable consequence of such a threat is to place the person to whom the threat is communicated or the person threatened in reasonable fear that crime will be committed. So that's the language we're discussing tonight. And we've received written testimony, and we will also hear oral testimony today by Joe McDonald, the Chief Prosecutor. Thank you for being here. Please come on up. Stephen Hattori from the Public Defender Services, thank you very much. And Jocelyn Roden from the Public Defenders. We have written testimony today from Richard Dirks of the Public Defender, Karen Carpenter, and some information that was not testimony, that was provided by Harold Parker of the Guam Legal Services. We also have testimony, I think that was yours then, submitted by the AG's office. Is that correct?
That's correct, Madam Vice Speaker.
All right. Okay, so we'll begin with you, Mr. McDonald, please.
Buenos dias, Hafaday, Madam Vice Speaker and Madam Secretary. Thank you on behalf of the Attorney General for inviting us down today and for your quick action in remedying the deficiency in the statute. So at this time, I'd just like to read our written testimony into the record, and then at the appropriate time, I'll take questions. Hafaday, Senator, and members of the committee. We support the enactment of Bill 175-34. We appreciate the lead taken by Vice Speaker Terlaje for quick action proposing new language, amending the Family Violence Act in response to the Supreme Court of Guam's recent decision in People v. Shimizu, 2017, Guam 11. The need for quick action was recently demonstrated in a case where a husband locked his wife in their house and threatened to shoot her with a large metal lug from a slingshot because she would not give her cell phone password to him. Because 9 GCA Section 3010A2 was declared unconstitutional, the defendant could not be charged with it and was instead charged with terrorizing and felonious restraint. The case could have been assigned to the Family Violence Specialty Court, where were we able to charge it as a family violence violation, where the prosecutors, defense attorneys, and judge are trained on how to handle family violence matters. Although we are in support of the proposed bill, we believe the proposed language may be unworkable. The wording found in the Shimizu decision is therefore preferred. The Shimizu decision stated that there needs to be a requirement of imminence, reasonable fear, or both. In paragraph 33 of the decision, the Guam Supreme Court cited several domestic violence laws from other jurisdictions which have such requirements. Based on those statutes and the Shimizu case, we would suggest the following change to Bill 175-34. And under subsection B proposed by the Office of the Attorney General, that would be placing another family or household member in imminent fear or reasonable fear of bodily injury to the family or household member or to another family or household member. With our recommended change, we stand in full support of the bill. Thank you for the opportunity to provide testimony.
Thank you very much. Mr. Hattori.
Good evening, Madam Vice Speaker and Committee Chair Terlaje, Senator. On behalf of the Public Defender Service Corporation and as a practicing attorney appearing before the courts of Guam, I testify today on behalf of Bill 175-34. Now, we're here today to attempt to fix the family violence statute made necessary by a recent Supreme Court ruling. It is commendable that the legislature has moved this quickly to remedy the unconstitutionality of the statute. As we speak, and as the Chief Prosecutor mentioned, the Attorney General has decided to upgrade 3010A2 charges to felony terrorizing. In layman's terms, and contrary to both common sense and public policy, if you punch your spouse, you get charged with family violence as a misdemeanor. But if you threaten to punch your spouse, as the law stands now, you will be charged with felony terrorizing, the effect of which is to deprive citizens, defendants, and victims alike the many benefits afforded by the Family Violence Treatment Court. Now, the Supreme Court of Guam ruling in People of Guam versus Shimizu invalidated the family violence statute as being inorganic and void for vagueness. Specifically, the Guam Supreme Court indicated that the family violence statute failed to provide fair notice as to prohibited conduct and failed to establish minimal guidelines to govern law enforcement. Throughout the opinion, the Guam Supreme Court indicated that at the very least it should be required that the victim's fear be reasonable or that the fear be of imminent bodily injury. The void for vagueness doctrine can easily be repaired by the following amendment to 9 GCA Section 3010A2. And I quote, "You'll be placing a family or household member in reasonable fear of imminent bodily injury." This simple amendment addresses both the fair notice and minimal guidelines concerns held by the Supreme Court when they struck down this particular statute. And I think both the AGs and our office are in agreement with this minor change. I further support a public hearing to address the entire family violence statute. Initially, family violence cases were diverted from the criminal calendar. Through diversion, the courts expeditiously resolved cases without a requirement that a party plead guilty. Such matters were resolved in the counseling session, often required by a diversion stipulation. Diversion had limited impact on immigrants. Diversion also did not affect a soldier's ability to possess a firearm. When the law was changed, requiring individuals to plead guilty, many collateral consequences followed. Families have been divided by deportations. Servicemen are unable to perform their duties requiring the use of firearms, including our own guardsmen. Our construction workers are unable to perform work on our military bases due to a plea of guilty. Perhaps now is the time to consider returning to the diversion mode of resolving family violence cases. While it is a suggestion that may be better left for another day and time, it is a humble request that is worth exploring. Thank you for your time and the opportunity to address this legislation.
Thank you very much, Attorney Hattori. Ms. Roden?
Yes, good evening, Vice Speaker Terlaje.
Oh.
Can you hear me? I don't normally need a microphone to be heard, but good evening, Vice Speaker Terlaje and Senator Regine Lee. Just so we're clear, I stand firmly shoulder to shoulder with my colleagues, the Director, Stephen Hattori, and Senior Attorney, Richard Dirks. And to help you, if you'd like to field any questions, I brought every iteration of the family violence statute, starting when it was passed in December 30, 1994, in Public Law 22-160, where a very young Attorney Terlaje was the legislative... Still young legislative attorney. Back to the blue books as we know it, all the way up to the new green books in 2005, and I even brought the codifications up to 2017. Basically, the two things that I'd like to just point out is I support that we should follow, or perhaps the legislature should take a look at the Shimizu decision to take its lead on the recommendation as to the imminence requirement. As far as reasonable fear, that has actually been addressed in People versus Root, the 2000 case, where terrorizing the statute was examined by the Guam Supreme Court. And it is quite plain to me as a practicing attorney of many years that your proposed statute tracks the terrorizing statute, 9 GC 1960. So I'm at this point also requesting the legislature to, and echoing the thoughts and requests of our director, for the legislature to look at having a public hearing to review the entire family violence statute. It is my thought that passing this proposed legislation would be a goodwill's intent to stitch what is a complicated fabric that has been modified over time. Perhaps it is time now for the Guam legislature to look at the needs and concerns of all of the people in our island, citizens, non-citizens, people who will be affected by the family violence statute, victims, people who serve in the military, the reservists. So at this point, I also echo that point, that we should probably look at the entire statute at this point. So with that, I request the court, that's my habit to say the court. I request the legislature to look at the imminence provision suggested by People versus Shimizu, and as my director had recommended, to review the entire family violence statute at some point. Thank you.
Thank you. Attorney Dirks?
Good evening. I was on the task force that drafted both of the prior family violence laws. So in part, I'm saying that I played a key role in drafting the unconstitutional statute. I don't know whether that's a good thing or not. So I've tried to be very careful this time. I filed some written input that is very nitpicky, if you will. I'm not going to go into all of that because, like everyone who's spoken here so far, I think the statute can be fixed with a couple of very simple changes. I don't think it's bad when we can't charge family violence if it's really a terrorizing case. If somebody's threatening someone with a shotgun, that's terrorizing. We have a good statute for that. What we need here is a statute for less serious offenses that happen usually inside the home. I think the Attorney General's suggestion was very good, except the fear can't be either imminent or reasonable. It's going to have to be both. It's going to have to be both. A fear that is, or a threat or a fear that is open-ended into the end of time is going to be too vague, and Shimizu addressed that. A fear that isn't reasonable. Someone who is afraid every time their husband walks through the door, that is not going to pass muster either. So making it reasonable and imminent, I think, does a great deal to solve the problem. We also need a mental state. Right now, we also need a mental state in the statute. Right now, there isn't one. The former statute had the mental state of reasonable, and I noticed that when the legislature passed subsection 3, I believe it's now knowingly or intentionally, that would keep those two parts of the statute together. Since we're talking about communications and we're going to be treading in territory where the Shimizu opinion didn't help us much, which is speech, pure speech. Probably knowingly or intentionally would be a better mental state. Another thing, and I addressed this more in my written response, is I'm troubled by the idea that the communication can be made to another. We're calling this family violence if the first person to whom the communication is made is a family member, but there's no requirement that that person be either the target of the threat or that they be afraid. If the third person is not a family member, but they are the one who is the target, or they are the one who are afraid, if it's the third person in the chain, there's no requirement that they be a family member. It's still family violence just because it was initially communicated to the first person. I don't think that's the intention of what we want to do with the act. I think what we want to do is address the situation where people are together or close to being together in a small space. A threat is articulated, and there is to a family member who becomes in fear. Another problem with this, and I've actually seen a few arrests on this, so we may need a statute, frankly. I mentioned this briefly in my written response, but we're seeing situations where a communication will be made in a way that it doesn't last, usually by a phone call or Snapchat. Person A communicates to person B, B communicates with C or D It goes down the line until eventually somebody is frightened by what they think A said. There's a danger that this statute is vague enough to be extrapolated into that pure form of communication. I've actually seen a young man arrested who he never left his house. He never talked with the person who was afraid. And actually he was talking about hurting himself. And I don't think that's what we want to do with the statute either. We're trying to cover the situation where if people are in a heated argument, one of the lines they don't cross is you don't put the family member in fear that now or very soon I'm going to hurt you, and you're reasonable to believe I'm going to hurt you. That's a crime, and it should be. And I thank the legislature, particularly the Vice Speaker, for getting on this so quickly after the court spoke. Thank you.
Thank you. If you don't mind, I'm going to ask, we have Karen Carpenter also signed up. If you could just join us in the panel. And looks like Charlene Quintaniza. All right, thank you. We'll hear your testimony, Mrs. Carpenter, and then we'll have questions.
My testimony is very brief. My concern was that when you talk about threat, it doesn't say, there's no definition, so I would suggested that under section 23010, definitions number 2, communicating to a family or household member through words or actions a threat to commit. Because threats don't have to involve words, and that would make it clear. I'm just concerned that somebody's going to read this and think it has to involve words, and you know, somebody chasing somebody around the yard with a machete isn't necessarily words, but it's definitely a threat.
All right.
That's it.
Okay, well, thank you very much. If you don't mind answering some questions, first of all, I want to assure all of you that thank you for bringing up the point that the family violence statute overall could use some changes at this point. I think we've seen a lot of the benefit from it, and we've seen also some things that we could fix right away, and we'll try to do that. So I'm going to try to put together a round table. I know that Senator Lee's also very interested in that, and I'm happy for your participation. I think you are the core people who I would like to see participating. It represents a very good sector of who's dealing with the family violence cases. All right. So the decision, I want to just make it very clear what your interpretation is. I read it to read that it's requiring reasonable and or imminent. And when you say it must include both, Attorney Dirks, is that you're saying the statute must, or just practicality we should?
I'm sorry, can you just turn your mic on?
Not used to these, sorry. To withstand judicial scrutiny, I think it requires both. The fear by the victim must be reasonable. If she's afraid of green hats and her husband comes in wearing a green hat, that isn't going to be a reasonable fear. I mean, that's an extreme situation, but the Shimazu court did discuss this, and it was part of the briefing. And imminence is required because if, you know, when our son turns 18, I'm going to chase you with a hammer. Well, if that's not going to happen for 10 years, it's not a real threat. Of course, there's a giant gray area, right? But there's a requirement, though, that the threat have to be communicated in such a way that something bad's going to happen now or fairly soon, and because of that, the victim has a fear that is reasonable. And that's my reading of Shimazu. I also checked some of the other statutes they cited, and that seems to be the requirement. If it's imminent, too, it also, just by the way it'll work out factually, it means that the actors are going to be close in time and place, and I think that's what we're trying to punish with the statute, not pure speech.
All right. A Chief McDonald?
Yes.
Your testimony, you're suggesting imminent fear or reasonable fear. Do you think this suffices for the statute? I mean, obviously.
Yeah.
I mean, for
so the way I would view it is, or that we would view it is, the decision itself says or, so it is a disjunctive, and that's what's required for notice, is that it's either imminent or reasonable. And to require them both would require, of course, two determinations by a fact finder that they were both present. So that's not what the court had said. The court had said either or both.
All right. So let's say that you're correct, and that's what the court says. But what do you think about the public defender's suggestion of reasonable fear of imminent bodily injury? So
I think I understood it to be reasonable fear of, yes, reasonable fear of imminent bodily injury. That reasonableness requirement, it's present in what we're recommending.
Say that again?
It's also present in what we're recommending. We're
Yes,
just
that's correct.
allowing for more flexibility because of the diverse nature of facts that can happen in any family violence situation.
All right. Imminent fear.
Could I ask what the wording is that you're proposing?
Yeah.
Maybe we're not at odds at all.
Okay, could we just take one let's give everybody a copy of each other's testimony so you can see,
Okay.
yeah, they're all spelled out. Let's just do that. That's very helpful.
Only my, I've got yours. Yeah.
Thank you. Okay, so we see the AG's office is proposing imminent fear or reasonable fear of bodily injury. The public defender, the director of the public defender is proposing in reasonable fear of imminent bodily injury. All right, I guess I would like a little bit more testimony, if you're willing, about each other's proposals. It sounds like you read it like I did. It's an and, or.
Or.
Yes. Or that or would be sufficient, but what do you think is best? I mean, if we have our chance right now to change it, then do you believe your recommendation is best for your purposes?
Yeah,
more flexibility, I guess?
I think what we're looking for, again, is trying to cover the situations that would be constitutionally okay with respect to notice. And so the requirement, for instance, of reasonable fear of imminent bodily injury is we're not talking about reasonably believing that there's bodily injury. We're talking about imminent bodily injury. So when you think of all the permutations, I think our language catches more of those permutations. as, and this law is, even though it has been struck, we at least have so many examples of this type of conduct that's prohibited coming up that we will need to, although keeping in mind notice, constitutional notice, we will actually need to have some flexibility in the different situations that would come up. And again, it's also, it's intended to protect our family members, so I think that's sort of an expansive or at least varied opportunity to charge is probably preferable. Again, the idea is to have this sort of conduct go through the family court system, which is a specialty court, which is designed to handle this. So the flexibility, I think, is justified in that instance.
All right, and so if your language says placing another family or household member in imminent fear, does that mean it could be unreasonable?
No. Imminent fear just I think imminent fear just means that, which is it's going to happen.
Okay.
And that reasonableness, you know, it's imminent fear or reasonable fear. So,
all right.
To the other thing I would point out is it's in the eyes of the victim.
Right. Okay. All right.
And the reason why I made them both requirements was because the Supreme Court in that ruling, while they used the phrase "or" at times, they said that the statute was void for vagueness for two different reasons. One was that it didn't provide fair notice, and the other was that it didn't provide standards, the minimal guidelines to govern law enforcement. And so when you include both of those, imminent, well, the reasonable fear would be, you know, the minimal guidelines that law enforcement would govern law enforcement, and the imminence. It doesn't prohibit all threats, just imminent threats, you know. And so that would provide fair notice to the residents as to exactly what is prohibited conduct, not just any kind of threat, but it has to be one of imminence. And, you know, just like the example that Mr. Dirk cited with, you know, the threat that may or may not happen 10 years down the road. And so the Supreme Court in Shimizu indicated that, you know, there were two problems, the fair notice and the minimal guidelines. And so I think to be safe, we should include both, because one addresses the fair notice defect, and the other one takes care of the minimal guideline problem.
Did you have any comment on that?
I think we're actually on the same.
Oh, yeah,
we're actually on the same page.
That's right. Okay.
At the risk of sounding redundant, Mr. Dirks.
Here you, yeah.
Mr. Dirks can explain that we are actually on the same page. If you,
Okay, great.
Okay, I
Mr. Dirks.
think where we're at is the government is proposing imminent fear or reasonable fear. Conceptually, I'm sorry, I don't know what imminent fear is. Imminent is something that's coming. It's something that's about to happen. If you are placed in imminent fear, are you actually afraid? I don't think so. I think the requirement, what we're trying to punish, is the person who puts their family member in genuine fear, that the only limitation is that it must be a reasonable fear. What are they afraid of? They're afraid of imminent bodily injury, a bodily injury that is coming. It's on its way. It's vague as to time, but if it's imminent, it can't be too protracted. I'm going to beat you up at our son's 21st birthday. I'm not sure, quite honestly, that imminent fear has a meaning that we can use in court. So
All
I
right.
agree with Stephen and Jocelyn that I think the appropriate language is that the family member be placed in reasonable fear of imminent bodily injury.
All right. Can I ask a different question then? Regarding if we keep, sorry, just one more. If we keep the word threat, does anyone have any objection to including Mrs. Carpenter's suggestion of words or actions?
I think she's spot on.
Yes, I know I've read this in other jurisdictions, and I think I took it out because I thought there was another statute that uses the word threat on Guam and to include both. So, but I have no problem including that. Does the Attorney General's office have a problem including that? Sorry, could you repeat that?
Yeah, sorry, the communication would come either way, so that's...
All right. And what about something else that I had included here, and I understand from your testimony it may be problematic, but I was trying to cover that the threat might not be to bodily injury to you, the family member, but perhaps, or that one family member, but to another family member in the room. A lot of times you hear the stories about the children or another family member being that they're threatening, they're telling you they're going to hurt someone else in your family. I mean, do you think that needs to be covered in this statute?
That's already covered in the terrorizing statute.
In the
Vice
terrorizing?
Speaker, yes. Because you could make a threat to the target or the person you're speaking to, or
Right.
to pass it to another person, and making that the person who's listening to your statement afraid that you'd actually carry it out.
All right, and I heard your point, Mr. Dirks, that charging them under terrorizing, in your opinion, is fine instead of allowing them to fall under the family violence in certain cases.
Actually, one of the things that crossed my mind when I saw the language from the terrorizing statute to commit a crime of violence dangerous to human life, if we put that in this statute, we might inadvertently be reducing terrorizing to a misdemeanor if a family member is the victim. And I don't think anybody's arguing for that. So that's why, and the bodily injury is what we went with in the original statute years ago. Bodily injury is defined in the criminal code, so we have a definition we've been using for years. I'm a little worried also about the third party aspect, because we're seeing a lot of parents getting arrested, a lot more parents getting arrested for physical punishment of children than we used to. And so much depends on how we were raised, right? I mean, there's some cases you look at it and of course that person deserves to be locked up. There are others where the child's done something horrible and one parent usually is the punisher, and they act, and they may not have committed child abuse, because it's a different definition, and parents do have the authority to use corporal punishment, but we're seeing people getting charged under the gray area in the family violence statute. Of course, I don't always agree with the charging decisions the AG made, but if I did, they wouldn't be aggressive enough. So.
Okay. And then finally, the mental state. I know you said you think we need one. Does anyone else think we need to include a mental state in this subsection?
Well, I think the mental state is always, since it's model penal code, will always reflect recklessness, at least. So, and then the question becomes, well, what does that mean? How can you recklessly communicate a threat? Well, you could be drunk, and so you're reckless in your words, or you're reckless in placing somebody in fear as opposed to intentional. So the intentional aspect, I understand the need to clarify the mental state, but again, if we're looking to treat it as a specialty court issue, then we probably want to include a little bit more, at least charging flexibility, so that, or arresting flexibility, so that at least we're allowed the family to repair itself in that way.
I think it's necessary in this statute to include a mental intent.
You know,
I noticed the court didn't.
Madam Vice Speaker, I'm always an incrementalist. If the problem hasn't presented itself, then let's not invent the problem. The Supreme Court has identified a problem. Let's go ahead and allow the statute to take its course.
All right, does Attorney Hattori, do you have any comment on that mental state?
Here's the family violence mental state.
I was actually going to make that part of my testimony, but then I realized that it's stated elsewhere in the statute what the requisite mental state is. At 3020A, so it already sets that as a...
Where? At where?
Section 3020, subparagraph A. Any person who intentionally, knowingly, or recklessly commits an act of family violence as defined in Section 30-10.
Okay.
It's addressed. It's addressed.
I'm so sorry. We can leave it that way if we want, but what it means is that the government will have to choose one, perhaps at their peril. I think this does obviate my worry, which someone speaking, muttering under his breath, not knowing he's being overheard. I'm not sure that should be criminalized, but...
All right, I appreciate that. And I appreciate all your testimony, and I will consider all the detailed points that we weren't discussing today. I will also look at those, but I'm going to open for Senator Lee to... Can
I say something?
Yes, of course.
So, I think I understand what you're saying, Richard, although I'm not a lawyer, but I think so. But so my concern, though, is, I mean, because you used the example of someone who's drunk. Sometimes they're serious. So, I mean, just saying that because they're drunk and they're saying, I'm going to kill you, they're not, that is not necessarily true.
I'm sorry, the example I used was someone who doesn't know anyone is there to hear the threat. So, no, you and I are on the same page. We usually are, Karen.
Okay.
Would that be covered under your example of knowingly or intentionally?
Yes, I think so. Yes. I think so.
Okay. Okay, Senator.
Yes, thank you so much, Madam Chair, and thank you all so much for participating. Really appreciate it. Sorry about the microphones. I just want to make sure that we get your valuable testimony on the record. So when the committee comes back, we can make sure we capture all of your suggestions. My one question, or I guess I have just a couple questions for the panel. Maybe if anybody could give me some input about page 2, line 7, so it's the beginning of subsection 2 or part 2, communicating to a family or household member a threat to commit or cause to be committed bodily injury, and it continues. Do you think that that communicating aspect of it maybe potentially limits cause to speech and might be considered a free speech issue in the... I just wanted to get your opinion. Is that something that somebody could use? I just want to make sure that the statute is, I mean, this law is as strong as it could possibly be.
The statute's going to be tested, okay? It's going to be thrown into an arena. But this word has been tested before. If you put in communicating by word or action, as Karen Carpenter is suggesting, that in part gets past the idea that we're talking about pure communication. And if what is being prohibited is a reasonable fear of a risk of bodily injury that's going to happen right now, I think or very soon, I think the only constitutional issues that will come up are when the communication itself is ambiguous. I'm going to teach you a lesson, you'll be sorry. Maybe that person is saying, wait till you get the legal papers Monday morning. We don't know that, but once again, I'm not sure that'll be thrown out on free speech grounds. It'll be a matter that will go to 6 or 12 people, and they will decide on the basis of all the testimony whether this was something the person had a right to say, or whether the result was they put a family member in reasonable fear of bodily injury. If the guy's waving a hammer when he says, you're going to be sorry, that's a little different, which is why I think the suggestion Karen made is very important.
Thank you.
I would just like to comment on that idea and having further reflection on it about communicating through words or actions. Now, we all have children, and they no longer communicate like they did with words or actions. Sometimes it's an emoji.
We can add those.
So to limit it to what we understand to be communications coming from the 20th century might not stand the test of time. So we might want to think about, a fist, a gun, or I remember back when we had pagers, we'd make numbers into words. So that communication aspect varies with how humans communicate normally. And it could be a look, right? A look that poor household person has seen before that precipitates extreme violence. So I would just make sure that the legislature, when considering that language, remembers that the idea is communication.
Thank you. Just one last question.
Well, could I just add something?
Yes, sure.
When I first read the bill, I was actually really happy with it, because what it appears to do is it removes terrorizing when a family member is a victim from a felony to a misdemeanor. And on behalf of our clients, really, I'm sure they would all prefer that. But I'm not sure if that is what the legislature intends, and I don't know if, as a policy, that's a good thing. I mean, we definitely do need terrorizing in the proper situation. But that's why when you transfer the language of the terrorizing statute into the family violence statute, then it opens up the arguments to at least our office to make that that felony terrorizing when it involves a family member should only be charged as a misdemeanor. And that's why the language we proposed was recommended by the court. We know that it would withstand scrutiny at the Supreme Court level, and it would avoid this conflict that's going to happen when we start filing motions to dismiss terrorizing, because there's a more specific statute that governs when a family member's involved. And that's all I wanted to add.
Thank you, Mr. Torrey.
I'd also like to comment that this subsection 2 has been a very useful subsection where we have cases that are charged as terrorizing, but neither side is really confident of what the jury's going to do. Having this misdemeanor sort of straddle the middle ground where the person is put in fear of bodily injury, though not necessarily a crime of violence dangerous to human life, it has been a very useful statute to have on the books. And I agree with Stephen, and I'm sure the prosecutors agree too, that the language bodily injury, a crime of violence dangerous to human life, I don't think that should be there, because it runs the risk of reducing terrorizing down to a misdemeanor.
Thank you. Actually, yeah, I had a question about that as well, if it might be a fact issue later. Okay. Again, I really appreciate all of your expertise, and I appreciate you taking the time to comment on this bill, and I really appreciate the Vice Speaker for taking swift action to address this, and I look forward to working with all of you to continue to strengthen what we have in existence, and maybe look forward to looking at what we can do to address wider issues. But again, I thank the Vice Speaker, and thank you, Madam Chair.
Thank you very much. So I'm going to wrap up the part of the public hearing regarding Bill 175. Thank you again for testifying. I want to also thank all the service providers and first responders to family violence victims for their efforts. And the month of October is Family Violence Awareness Month coming up. So there are many community organizations and agencies that are working with families and perpetrators to make our community safe, and especially all of you, and I want to thank all of you for that work. Thank you very much. There being no additional individuals to testify on Bill 175, we'll keep this open until October 10, 2017 for the acceptance of any additional information or public testimony. You may submit testimonies to my office directly here at the Guam Congress Building, or through email at senatorterlajeguam@gmail.com. So the second item on our agenda is, you are all excused, thank you very much, unless you're staying for Bill 177. So Bill 177, the intent of this is to ensure the protection of victims and witnesses of family violence. It was motivated by news reports of persons committing further acts of violence after arrest and pending trial, such as the 2013 tragic death of Emma Catapang Cepeda, who was shot to death in her home at the age of 35 by her estranged husband while he was on pretrial release on charges of terrorizing and family violence. Cases in Guam and other jurisdictions have proven that arrest, protective orders, and strict release conditions issued by the courts are sometimes not enough to deter further violence on release pending trial. Electronic monitoring systems that notify victims and law enforcement when the defender violates a stay-away order may help to ensure victim safety pending trial. And the court is establishing a pilot program, or they established a pilot program and they have just received funding in the 2018 budget for an electronic monitoring program. So we were hoping that this bill could be tied into their plans. The judiciary has submitted testimony. Are you going to testify on behalf of the judiciary?
Yes, Madam Vice Speaker. I'm here to just reiterate the written testimony from our administrative director, John Lizama, and answer any questions that you might have.
All right, thank you. So yeah, so we've got written testimony by the judiciary, and thank you for being here. All right, and so let's just begin with who we've got signed up. Melanie Brennan, written. Tricia Suzuki, written. Hill Leon Guerrero, written. Joe McDonald, will you be, thank you. And Stephen Nattori, Jocelyn Rodden, Richard Dirks. All right, let's begin. Shall we begin with Melanie Brennan?
So, Madam Speaker, just basically, just to reiterate our AOC's written testimony, the concern is that the manner in which Bill number 17734 may affect its current efforts to properly assess, classify, and supervise pretrial defendants. Specifically, Section 2 proposes to amend Chapter 30, Title 9, GCA, Section 30.21, Conditions of Release to include number 8, an order requiring electronic monitoring of home arrest, or electronic monitoring that is capable of notifying a victim if the defendant is at or near a location from which the defendant has been ordered to stay away. The court shall indicate the supervising entity and may order the defendant to pay for the monitoring service. The supervising entity or electronic device should immediately notify the victim and law enforcement officials if a stay-away order is violated. The judiciary has yet to secure a contract for EM services. Additionally, rules to govern the use of EM have yet to be adopted. The proposed legislation seems to imply that family violence offenders will need to utilize GPS monitoring to track real-time movement 24 hours a day and 7 days a week, rather than devices that work off radio frequency and send alerts when entering or leaving inclusion or exclusion zones. The judiciary suggests that some allowance be built into the bill to allow for a choice among technologies when determining the best method of electronic monitoring. Additionally, the task of immediate victim notification should be defined and assigned to a particular responsible party. Under current law, the AG's office bears some responsibility for victim notification. Understanding that the notification contemplated in the bill relates to violation of stay-away orders, there would need to be a coordination between the supervising entity, which would probably be Probation Services, and the Office of the Attorney General, because they have the Victims Advocate Reaching Out, the VARO program. And also, the methodology used for determining who has to pay for EM services is not identified. The bill indicates family violence offenders will undergo a risk assessment. We read the bill to require that our personnel, probation, be trained in lethality assessments. This is something which is planned, but we have not yet undertaken. For all reasons articulated, we would ask that if the bill is passed into law, that its effective date be no less than 6 months from the date of enactment, so that the judiciary can properly train our personnel in lethality assessments, develop a cooperation procedure with the Office of the Attorney General, and also procure the EM service and adopt rules for the use of EM.
Thank you very much. Chief McDonald.
Thank you, Madam Vice Speaker. We, the Office of the Attorney General, do support Bill 17734, COR, providing for the release of defendants with conditions that provide for electronic monitoring. We, however, provide additional consideration for the committee. We believe in the phased-in implementation. Much like the judiciary has spoken, we believe that whether the risk of homicide posed by a defendant on release, like the husband of Emma Katapang Cepeda, is sufficiently mitigated by electronic monitoring is certainly open to debate. A spouse in an emotionally charged state may very well take action whether or not the spouse is being electronically monitored, just as much as the spouse with a court-ordered stay may be willing to commit homicide as a last fatal act. So risk monitoring principles would require that this type of high risk be taken incrementally, as the empirical data supports increasing levels of risk-taking. Since the court has adopted the Ohio risk assessment system to better gauge the risk of non-appearance and/or risk to the community, a prudent approach would be to phase in the use of electronic monitoring and only permit it for the riskiest situations after the empirical data has been studied and the risk-taking is supported by historical performance. For instance, it may be rolled out to nonviolent drug offenders and property crime defendants on house arrest so that this use is understood. Then gradually, it may be provided to offenders who pose more risk. Similarly, rather than release on house arrest with allowance for work-related travel, electronic monitoring may be provided as an option so that compliance with conditions can be monitored remotely, a cost savings that would mean less in-person monitoring to probation officers. These types of considerations are especially important considering that we are not informed of the technology that will be used. The other point is that we would ask that there be a clear finding that electronic monitoring is a privilege and not a right. We recommend that it is not to be provided in a matter of course to all otherwise eligible defendants. The statute should include that electronic monitoring is a privilege and not a right. Accordingly, we recommend the following language added to Section 1 relative to intent. quote, as a defendant who poses a risk of non-appearance or risk to safety of the community may be lawfully held instead of released, the legislature finds that release with conditions for electronic monitoring is a privilege and not a right. We would also recommend that the electronic monitoring program be self-sustaining, so that taxpayers are not burdened by defendants tampering or destroying electronic monitoring devices. There should be a cap imposed on the amount of electronic monitoring fee waiver allowed by judges. For example, no more than 5% of all electronic monitoring devices may be provided to those seeking waiver of the fee. It'll be a waiver cap. It is also recommended that the amount over and above the cost of electronic monitoring be charged to those who would seek the privilege, so that a reserve can be established to reimburse the electronic monitoring program in the event the defendant intentionally or inadvertently damages the equipment. We would also ask the legislature consider criminalizing tampering or destruction of the electronic monitoring devices. So as an additional risk mitigation, we recommend imposing a criminal sanction, and it can be read simply as penalty. It shall be punishable as a misdemeanor for any person to intentionally tamper with or damage electronic monitoring equipment. And so with our recommended change, we stand in full support of the bill. Thank you for the opportunity to provide testimony.
Thank you very much. Attorney Atori.
Thank you. On behalf of the Public Defender Service Corporation, I would like to offer the following testimony. So the bill on its face is quite admirable. One must remember that individuals charged with crimes are presumed innocent until they are judged guilty. Now, the intent of the bill is to recognize that the courts of Guam may consider risk assessment tools in determining whether a defendant is either a flight risk or a danger to the community or persons. I think this is an essential part of the bill. Right now, it's not a factor that the court is even authorized to consider. Our office just has not challenged that. We haven't appealed any denials of bail based on the court's reliance on a risk assessment tool that has not been authorized by law. So I think this is an essential part of the bill. Okay. And the bill goes further. It explicitly provides the courts with an additional tool of supervision, i.e. electronic monitoring. It even reduces the disparate impact on the indigent population by allowing the fee to be waived for those that are unable to afford the ankle bracelet. For the electronic monitoring system to sustain a constitutional challenge, this issue needs to be provided for. This provision needs to be provided for. I know other jurisdictions, they have sliding scales, or they allow some of the fee to be paid off by community service, but we've submitted some articles in support of our testimony, and which will really show that without waiving these fees or providing other ways of paying for them, it really becomes another debtor's prison for the indigent. And so we appreciate that the committee has included that language in the bill. And these are all admirable improvements to the law. But some confusion is created by Section 4 of the bill, which changes the bail statute. But it appears to impose a mandatory presumption of confinement for a defendant charged with violation of a court order. And, you know, we're all familiar with the Orlando Cepeda case, but Mr. Cepeda is an outlier. It would be unfair to cast all citizens charged with similar crimes in the same light. And that is exactly what this bill does. The courts of Guam currently considers a violation of a court order as a factor in determining release and release conditions. I know, like in the magistrate hearings that I've attended, the magistrate judge is extremely reluctant to release anybody who's facing a charge of violation of a court order. So it already is a factor that the courts take into account. I'm just concerned that the courts might have these individuals all use ankle bracelets, even though the risk assessment tools would suggest that ankle bracelets are necessary. And I think the literature that I submitted would support that. There are many other defendants that could benefit from the use of an ankle bracelet instead of being confined at the Department of Corrections. Okay. So currently, many low-risk defendants are released with standard stay-away conditions even without the expense of an ankle bracelet. Very few are ever revoked for violating these conditions. The passage of this bill might be construed as legislative desire to incarcerate those charged with violating a protective order, and I don't necessarily believe that that is the legislature's intent. But I also want to thank the legislature for including language that would allow the court to suspend the fees for electronic monitoring of indigent citizens. This would ensure that electronic monitoring, when necessary, does not unfairly discriminate against our indigent population, and I've attached those articles addressing this concern. Thank you again for consideration of this bill. I think it's very important because it gives the court additional tools to help them decide whether or not an individual should be released on their own personal recognizance or in establishing a cash bail. Thank you.
Thank you very much. Attorney Dirks.
Thank you very much for this opportunity. I remember the last time the court tried electronic monitoring, and the technology just plain let us down. I'm going to keep an open mind, and I think it's a good experiment, and I think the probation department, the court, and the Attorney General have made some very, very good suggestions. I want to see how it works out. I also thank you for putting in the bill up the possibility of a waiver. The last time around, frankly, it wasn't a remedy for our clients. The technology last time required a landline, and most of our clients don't even have a landline. I don't know what it will require this time, but I look at this as being another way for people charged with serious crimes and access to money to get out of jail, and that's not my people. I am a little worried because of the legislative intent tying it to family violence. That was a murder. Yes, it involved family violence, but that was a murder. And the little fish, the many, many little fish who are caught up in the net would violate a court order before they would hurt their spouse. If a typhoon comes and she says, I don't care what the judge says, come over and help me and the kids, he's there. And that's the way most of them are. I tried in the written response to point out that I think the bill in the section about violation of court orders assumes that every victim wants the protective order that she's carrying around and that she zealously will support what the court does against the guy who violates the order. But that just isn't the case. There are a lot of people, and I won't go into all of this right now, but in criminal cases, virtually everybody gets a no-contact order. I've seen it happen with the woman in the courtroom begging the magistrate, no, I want him to come home. There's a no-contact order. And just because of the way the machinations work, it's 3 weeks to many months before that changes. People violate, and a lot of it is because of the victims didn't want the order in the first place. Our system puts orders in place very easily, and it's hard to get them lifted. It's even worse with civil restraining orders because the order goes in place, it lives for 1, 2, or 3 years, there's no further hearing. If the plaintiff, the petitioner, wants it changed, she's got to hire a lawyer. We take our clients back and we'll modify at any time. But if she hired an attorney, she's got to come up with a separate fee. And I don't think there are forms in the kiosk downstairs to say, we've changed our minds. We're going to try to get back together and give it another go. People violate the orders, and they aren't all bad. So the two things I focused on that troubled me is the section that modifies the bail statute. Let's see if I can point to it.
Section 4, yeah.
Yeah, it 4015C4. I think victims should be heard at all of these bail hearings. This statute would add a section that allows the judge to consider statements by the victim about prior threats or acts of violence. Of course the judge should hear that. But he should also hear from the victim who wants to come in and say, hey, I'm not really a victim. We're going to try to fix this. I know the court has to do its thing, but our family priority right now is getting back together. She should have the right to say that. And it troubles me a little bit because I get the feeling that all of us educated types think we know better. We think we know, I'd never go back in that relationship. Well, I don't have 9 kids with somebody, and that changes things. Give the women a voice, give them a chance to come in and say whatever they want, and they really have a very good idea of what they want. First, they may want him out so he's working. Maybe not coming home right now, but we'll go to church as a family. There are ways that can be compromised and worked out and keep everybody safe. But the judge has to hear all of it. And the statute currently allows the victim to have complete input. Our Victim's Bill of Rights, unfortunately, only kicks in if the victim gives written notice, which is too bad. But please don't pass this. We shouldn't silence a victim because it's inconsistent with what the prosecution wants, or it's inconsistent with how she should have the right to say, he or she should have the right to say whatever they want. The other problem that really troubles me is the material starting at 4020G. I realize that this was constructed in the hope of finding a class of people who were eligible for electronic monitoring, namely those who violate restraining orders. Come on down to the court and see who's really in front of the judge for violating restraining orders. People get caught voluntarily. There are guys who are stalkers, and they might fall into this group. But to build a presumption that anyone charged with violating a restraining order should not be released, we don't even do that for homicide cases. And then the next 2 sections basically deconstruct the presumption. So I'm not sure it adds anything to our current statute, and it raises a presumption that's very troubling for the 2 people who, during their motion to lift the no contact order, it comes out, well, we've actually been having contact for quite a while. We couldn't wait for the court hearing. The AG can still charge him. The judge has to enforce every no contact order. The judge has to do something, but it can be a lecture, it can be 5 or 10 hours of community service, or it can be throwing them back into jail. But please don't take away from the judge who is dealing with the situation right there, and the victim who is in court hopefully saying what she wants, and the attorneys who know the case best. Please don't take away from all of these people a judge with the discretion to do the right thing. As far as electronic monitoring, I guess if we've got the money, let's do the experiment. I am glad to hear probation have some very constructive offers about and I'm sorry, I guess it's the court, but she also saw this experiment the first time around, and I think it's very important to get the technology right and look carefully at what we're doing, because it just might work, it might not. Last time the technology let us down. So that's about it. I don't think we need to do this extensive change to our release procedure to just add a provision that one of the things the judge can consider is electronic monitoring. Let's do it. But if there is ever a $500,000 available for another project, if you approach the Attorney General or the Public Defender or probation, I bet we'll find another one for you. Thank you very much.
Thank you. Attorney Roden?
Yes, Madam Vice Speaker. I'm going to speak about the proposed electronic monitoring under the Family Violence Statute. My thoughts echo what has been stated by probation. If you do decide to pass the statute, that it be done in phases to implement current technology, because the first experiment, which I also had remembered because I was a practicing attorney, was expensive. The technology was not present to achieve the results that you envision at this point. So my thoughts are similar to the courts. It is also similar to Attorney General's office that perhaps electronic monitoring should be left for the riskiest situations based upon empirical data that he presented to you. And as well, I stand shoulder to shoulder with my director and Senior Attorney Dirks that electronic monitoring is only one of the many tools the presiding judge over the particular case has under the statute to decide whether a person should be released or not. With the implementation of the Ohio Risk Assessment System by the judiciary, I have noticed a consistent decision-making among the judges, which has been, to the most part, very smooth, has had very little problems, and took into account lethality factors. Actually, probation officers at this point are trained in assessing lethality factors with regard to family violence or dangerous situations not involving family members. So at best, I would say that the proposed statute should only be one of the tools left to the judge. And I'd like to address the proposed change to the bail statute at 4015. As it is now, the current family violence statute that it seems that you want to address the concern about the Cepeda case. The current family violence statute already gives the trial judge that discretion, that ability to assess whether or not they're going to release that person. And it has been my personal experience that they most likely will not. So perhaps G is not necessary under the current iteration of the family violence statute. And lastly, I'd like to point out that the current iteration of the family violence statute allows input by the victims of family violence to appear at court hearings, to give their input. So for you to restrict it to only specific incidents, that would limit them. So wouldn't it be better to let them just speak plainly, forthrightly, and openly to whatever the judge would ask? And let's place it to the judge to ask the appropriate questions upon examination. So that's my 3 points that I'd like to bring to you. And I'd like to thank you for the proposed legislation and giving us a chance to speak about it.
I'd like to thank you, and thank you all for the very, very good suggestions. And just a couple of things that I'm not sure all of you know, but when the judiciary came in and testifying for their budget, when they described this electronic monitoring program, they said it was going to hopefully save us $4 million at DOC. When DOC came in, they weren't as optimistic, and so that was their intent. I think it was to save money and to give the judges a tool to use. They were not very specific as to in which cases it would be necessary or used. So yes, this is this is me, and in particular in response to the one case and the facts where there was a protective order, and the victim had said in her sworn statement that he specifically said, if you arrest me or if you have me arrested, that you're going to have harm. And so it's only my intent, and I understand, and I try to make it as flexible as possible so that it's not mandating the court does anything except consider. So I tried to make it very clear that they still have all the discretion they've always had except with this additional tool. And I just put those things in to make sure they consider them at kind of like a checklist so that we don't ever hear a case where they just didn't hear that part of it, maybe. But that was it. But I totally agree with you. If this in any way might restrict what they hear from a victim, then that's not my intent. My intent was just to add it to the checklist of things that they were going to ask for. And so that we don't have that type of an incident where the victim knows that they have specifically threatened, if I'm been arrested or, you press charges against me, that I am going to come after you. That is specific types of case. I just want to make sure the judges don't forget to check if those are present. And, but I very much, I understand. I was wondering, Lonnie, if you could describe to us what types of technology, do you think the technology has changed since the last pilot program that you've tried out?
It definitely has changed, and we did run a pilot project, and it seemed to be more effective than 20 years ago, obviously. With GPS technology, which is a little more expensive than the radio frequency, you don't need a landline, you don't need a telephone, it operates off a satellite. And we seem to have gotten 80% coverage on island for the GPS. The radio frequency the coverage is all over the island.
I did include in here some ideal things that I thought it would be ideal, of course, if it notified, the victim right away. And I saw that in some jurisdictions, but it's very clear that in every jurisdiction, the technology changes so fast. They debate all the time, how useful it's going to be after they use it for a while. So I'm just wishing you the best of luck in developing this. I know that the judiciary will be very, very thorough. It hasn't developed its rules for this program yet, but I just wanted to hopefully influence that,
We are at this moment crafting the scope of work and also refining the protocols on who actually would be assessed.
Okay, great. Could you describe a little bit about your lethality risk assessment? I know we had talked very shortly that you guys are working on that right now.
So all of our reform efforts with juvenile justice, adult and pretrial involve risk classification. And so far we rolled out juvenile justice. The risk assessment we use for juveniles is very comprehensive. It's called the structured assessment, it's called the SAVRI, Structured Assessment of Violence Risk in Youth. And so it really covers all domains, and it identifies need factors, and actually it gives us a case plan that's driven by the assessment. So our juvenile probation officers have all been trained, and it's rolled out, and they're currently using it. The Ohio risk assessment refers to a system of tools, a suite of tools. And so at the pretrial stage, it just really speaks to pretrial. Will he come to his hearings? Will he attend his hearings if he's released? And is he a threat, a general threat to the community? So some of the judges who have seen the Ohio risk assessment aren't really satisfied with the pretrial assessment. They believe for family violence offenses that we should move further. It should really, really address not general threat to the community, but it should address the current charge, and also it should address the victim's safety. So that's specific risk to the victim. And so we're looking at the ODARA, which is a lethality assessment. And so we do have scheduled training before the end of the year. So I know that will satisfy the public defender's questions.
Great to hear that. And that's consistent with the risk assessment that you were suggesting?
Yes. since it's still, there's so many pieces of this proposal that are in flux and not understood, I think that's wholly appropriate. Right. Especially, I'm encouraged to hear that we're also thinking of a family violence specific, because you know, those are always some of the richest set of facts that you'll find on both sides of the equation.
And if I could, so the Ohio Risk Assessment System moves throughout the different junctures in the criminal justice system. So like even before a case is adjudicated, let's say somebody's going up for sentencing, there is a community supervision tool, and any of you folks can ask us. We are trained in that already, so any of you folks can ask us to administer those types of assessments for those cases, general jurisdiction cases. But for family violence cases, right now, we don't have training in that. We are looking forward to it, and we should complete it by the end of this year.
Great to hear. All right, and want to thank you all again very much. The testimony has been very, very helpful, and we'll hope we continue to work together to get this to be exactly how you think it should be. And again, you are the ones who are really whose advice we need to take in this matter. So. I just want to point out again, that it's a tool for use in all cases, supposedly, or right now, until the judiciary comes up with more specific rules. And I just wanted to make sure that it's a tool available in family violence cases where the facts might warrant it, and just to prevent any one of those fact patterns where we know there's been a specific threats like what we saw at that last case. All right, there being no additional individuals to present testimony, we'll keep, the committee will continue to remain open until October 10, 2017 for acceptance of additional information or testimony on these bills. You may submit it to the Guam Congress Building or through email to Senator Terlaje Guam@gmail.com. Thank you again for everyone, and thank you for your testimony, and thank you for your help.